Worried about going to court for your injury case? You're not alone. A lot of people assume that filing a personal injury claim means long court battles. Here's the first thing you need to know. Over 90% of injury cases settle before trial. Yes, 90%. That's not just a stat, it's the reality. And guess what? Insurance companies don't want to go to court either. It's expensive, it's risky, and a jury could award you more than they want to pay. So they're incentivized to settle and quickly. And that brings me to the next point. Documentation is everything. It's the foundation of your entire claim. Think of it as your case's paper trail. Here's what you need. Photos of the accident scene, medical bills and records, treatment logs, and letters from your employer about missed work. Also, journals documenting your pain, symptoms, and daily struggles. The more complete and consistent your documentation, the harder it becomes for insurance companies to deny or reduce your claim. Your paper trail is your power. Once you've recovered and we've collected all the evidence, we send a formal demand letter. This isn't just a note, it's a powerful legal document that outlines everything: what happened, who's responsible, your medical treatment, the final impact, and the compensation you deserve. A strong demand letter backed by solid documentation often leads to serious negotiations without ever going to court. In fact, many adjusters will respond quickly once they see we're prepared, organized, and ready to fight. But negotiation is more than just back and forth. There's strategy behind it. We always start high. That gives us room to move, but on our terms. We expect pushback, we're prepared for it, and we counter smartly. We use things like pain journals to show how your injury affects your daily life, expert notes to back up your treatment plan, testimony from doctors and therapists if needed. This isn't haggling, it's advocacy. And when you do it right, you often get a fair settlement without needing a judge. Now, in some cases, we'll recommend pre-suit mediation. That's when we sit down with the insurance company and a neutral third party, a mediator, helps us guide the conversation. It's not court. It's private, structured, and designed to find common ground. And often, it works. We've resolved cases at mediation that started with 0 offers and walked out with 6 and even 7-figure checks for our clients. So to sum it up, you don't need a courtroom to win. If your case is strong, if your documentation is airtight, and if your lawyer knows how to negotiate, you can settle out of court and still walk away with everything you're owed. But here's the catch. You still have to prepare like you're going to trial, because the better prepared you are, the faster they fold. So don't wait. If you've been injured and want to avoid court but still win, DM us, call us, or use the link in the description. We'll walk you through your options and build a custom strategy for your case, start to finish. Thanks for watching. If you found this video helpful, share it with someone who's dealing with an injury, or save it for later. You never know when you'll need it. I'm Joey Rafaeli with Rafaeli Law, and remember, you don't have to step foot in the courtroom to get the justice you deserve.